make her presentation, and just note that Ms Logan and Professor Mullally will be sharing speaking time in their opening presentations. Thank you.
Thank you very much, Chair. Thank you, members of the committee. On behalf of the Irish Human Rights and Equality Commission, I'd like to thank the committee for the opportunity to meet in this module of your deliberations. I'd like to briefly outline the institutional structure and legislative basis of the Commission for members of the committee and obviously members of the public who may be less acquainted with our work. The Commission is Ireland's independent national human rights and equality institution, and it was established in primary legislation in the Irish Human Rights and Equality Commission Act 2014, following the merger of the precursor bodies of the Equality Authority and the Human Rights Commission, and has been in operation since November 2014. Professor Siobhan Mullally and myself are two of 15 members of the Commission, appointed by our Head of State, the President, following an open competition and resolution of both houses of the Oireachtas. We have no reporting relationship to government and account directly to the Oireachtas for our statutory functions. We appear today to represent the views of the Commission for the record most recently contained in our policy statement on a new legal and regulatory framework on abortion in Ireland, in light of its international human rights obligations, submitted to the committee on Monday. It will come as no surprise to this committee that we do not have consensus at the Commission on this matter, but what I would say is procedurally Section 16 of our Act facilitates majority decision-making. In practice, that means that I, as Chief Commissioner, when we are meeting in plenary, take a vote on matters that are contested, and this matter has been put to the Commission now on 10 occasions since its inception in 2014. So what we bring before you today represents the views of 13 out of 15 members of the Commission, and 2 members of the Commission do not support the document in its entirety. The Commission's independence has been recognised internationally, and we've been awarded A status accreditation at the United Nations under the Paris Principles. These principles set out the necessary guarantees required to ensure that a national human rights institution can carry out its functions in full independence, free from any form of political or other pressure. Through a range of legal powers determined by the Oireachtas, we're mandated to promote and protect human rights and equality in this state. Of most relevance to today's discussion is Section 10.2 of the 2014 Act, which is to keep under review the adequacy and effectiveness of law and practice in the state relating to the protection of human rights and equality. Under Section 10 of the Act, the Commission is also mandated to consult with such national, European Union or international bodies or agencies having a knowledge or expertise in the field of human rights or equality, as it sees fit. Ireland has ratified 6 of the 9 core UN human rights treaties and is bound by those obligations as a matter of international law. For each treaty, there is an expert independent monitoring committee that oversees compliance. Ireland's compliance with these treaties is examined on a periodic basis, and under our legislative mandate, the Commission formally participates as the National Independent Monitor of Human Rights in this process and monitors the state's compliance with those recommendations. UN treaty monitoring committees have regularly raised concerns regarding the current legal position in Ireland in relation to abortion. Most notably in 2016 and 2017, the UN Human Rights Committee found that Ireland had violated a number of rights of the International Covenant on Civil and Political Rights, following complaints taken by Amanda Mellett and Siobhan Whelan, both of whom experienced pregnancies with fatal fetal abnormality. I use that term as it is well understood. I know it offends some, but it's important that we all know what we're talking about. In Amanda Mellett's case, the UN Human Rights Committee found a violation of Article 7, which is the prohibition on cruel, inhuman and degrading treatment, with the committee of the view that many of the negative experiences could have been avoided if Ms Mellett had not been prohibited from terminating her pregnancy in the familiar environment of her own country and under the care of healthcare professionals whom she knew and trusted. The committee also found a violation of Article 17, protecting the right to privacy, stating that the interference in Ms Mellett's decision as to how best to cope with her non-viable pregnancy was unreasonable and arbitrary. The committee also found a violation of Article 26, which is equality before the law, taking into account the financial cost of travelling to the UK. The facts of the 2017 Siobhan Whelan case were similar to those in the Mellet communication, and relying on the same reasoning, the committee also found violations of Articles 7, 17 and 26. So that's the prohibition on cruel, inhuman and degrading treatment, protecting the right to privacy and equality before the law. The State's response to the UN Human Rights Committee's views in the Mellet case, which included an acknowledgement by the Minister for Health, Simon Harris, of its views, an ex gratia sum of $30,000 and a detailed itemisation of the steps being taken by the State on foot of the case, further demonstrate the significance of Ireland's international legal obligations for domestic law and policy. UN treaty monitoring bodies are the preeminent interpreter of Ireland's binding obligations in international law under the human rights treaties it has ratified. Their views on Ireland are therefore authoritative and have a significant role in the interpretation, the application and the development of Irish law. Thank you, Chair. I'll pass over to Professor Mullally.
Thank